who have logged in. So we are going to go ahead and get started. Good afternoon, everyone. My name is Christy Brandt. For those of you I don't know or haven't met, I am Dickinson's Director of Planned Giving. And I want to thank you so very much for joining us today for a conversation about demystifying estate planning. I am really looking forward to introducing our alumni panelists to you. They bring decades of expertise to our conversation. But before we begin, I do need to quickly go over a few housekeeping items. As you have seen, the conversation that we're having today is in a webinar format. That means that you can see the panelists, but we can't see you. We had more than 120 people sign up for this event, which is really wonderful. But the best way to manage such a large group of people is really for us to minimize or limit the number of cameras and microphones that are in use during the conversation. But I do want to encourage you all to participate via the chat, as so many of you are doing already. If you haven't, please share your name, your Dickinson affiliation, your class year, in the chat so that we can see who's here and perhaps you can connect with some classmates or friends. Also, because we're going to discuss topics that touch upon legal and financial matters, I do have a few disclaimers that I would like to make. This conversation is being recorded, and while we know and trust all of you, we cannot make any claim of confidentiality related to any information that you may choose to share in your questions. This program will offer general information in a group setting. It is not a substitute for legal or other professional advice in a private attorney-client or any other professional relationship. It also is not a substitute for your particular needs for any specific legal concern that you may have. A number of questions have been submitted in advance. We will get to those at the end of our program. And I also encourage you throughout the conversation to submit questions via the chat. We will get to as many of those as we can. We expect about 15 or 20 minutes for questions toward the end of the program. As I said in one of the emails that you received, I really believe this is such an important conversation to have. Thank you all for your interest. I am so grateful to these panelists and to my colleagues for sharing their expertise with us. And I do want to let you know who you are seeing on your screens today. Sam Kramer is my amazing assistant. She is sort of driving our Zoom for us today. Beth Zach is our Regional Development Officer who works on the East Coast. And our panelists are Marcia Beidler, class of 1969, and Pat Van Allen Voigt, class of 1966. We'll get started after. I just have to share one personal note. I have had the chance to talk to Pat and Marcia, as well as Sam and Beth, over the last few weeks as we have talked about this program. And I just have to say that I am so grateful to them both. They have the most amazing way of talking, of conveying their expertise. They have a breadth of knowledge and a depth of experience and a genuine interest in helping people understand the best and the most impactful ways to think about estate planning. On top of that, they are kind and they are thoughtful and they are so very smart. And I am so grateful to have them join us. So thank you, Marcia. Thank you, Pat. And with that, I'm going to ask Beth to introduce Marcia for us.
Hello, everyone. It is my great pleasure to introduce Marcia Beidler, who graduated from Dickinson in 1969 with a BA in history. She then obtained her JD degree in 1972 from Rutgers University School of Law, and subsequently her master's in tax law from NYU Law School. Marcia was a member of the New Jersey, Pennsylvania, and Florida bars, and is certified by the Florida Bar as a tax lawyer. Marcia spent most of her 49-year legal career as a partner of the firm of Drinker, Biddle, and Reith in their Princeton, New Jersey office, specializing in estate planning for high net worth clients. In 1998, Marcia was inducted as a fellow of the American College of Trust and Estate Counsel. Since retiring, Marcia retired in 2019, and since retiring, she has continued to serve as an executor and trustee for several of her former clients. She currently manages 24 trusts with a total value of approximately $90 million. While at Dickinson, Marcia was also a Pi Phi. Their mission is to develop women of intellect and integrity. Marcia, you certainly embody this, and we are so grateful to have your expertise today, and I'll now turn it over to you.
Thank you, Beth, for asking me to speak, and good evening, everybody. I must admit, however, that when you first invited me to give this presentation, I was a bit intimidated. Excuse me, it brought me back to the time many years ago when I was preparing a speech on estate planning to present at my father's 50th reunion at Rutgers University. To make him proud, I very much wanted the speech to be entertaining as well as informative. Since I thought a bit of humor might help in that regard, I consulted my husband, who is my expert on all matters humorous, as to how I might make this speech more interesting and humorous. I knew I was doomed to fail when he replied, "Change the subject." While I recognize I am not going to have you rolling in the aisles with laughter, I hope to impart to you enough information to enable you to navigate the nuances of estate planning. Since my time is limited, however, the most that I will be able to accomplish is to give you a brief understanding of the tax laws that affect your estate plan and to raise some of the personal issues that might arise during the process. On that note, here are 10 important pieces of information and recommendations that hopefully will demystify estate planning. Number one, and probably one of the most important pieces of information, you need a will. If for no other reason than to name a guardian for a minor child of yours. Also, in many states, if you are now serving as a guardian for an adult disabled person, you can name your successor in your will. Finally, it is also important to have a will to name the person who will settle your estate and to waive the bond that he or she might have otherwise had to obtain. Number two, consider creating a living trust to avoid the expense and delay of probate. In many states like New Jersey, probate is very simple. I, in fact, never even went to the surrogate's court with my client when the client was trying to be appointed as an executor. It was just that easy. In other states, however, like Florida, it is quite cumbersome, causing delay and additional attorney fees in administering the estate. Also, some states like Pennsylvania charge probate fees based upon the value of the assets held in the decedent's probate estate. Therefore, if you live in a state in which probate is cumbersome or expensive, you may want to avoid probate with respect to the bulk of your assets by transferring such assets to a revocable trust during your lifetime. This trust is referred to as a living trust since it lasts for your lifetime, during which period you are entitled to all of the benefits and ownership rights held by such trust. You still need a will, but those assets transferred to the trust prior to your death will not be part of the probate process. Number three, do not try this at home. Yes, there are will and trust forms on the internet, but there is no will or trust that fits all situations. The only time I had to go for a court will reformation was in a situation in which the decedent had drafted his own will to establish a charitable remainder trust at his death. It wasn't pretty. In 1992, the attorney's fees and court costs in applying to the court for the reformation amounted to over $10,000. It would have been much cheaper to do the will, I can tell you that much. Number four, consult an attorney who is proficient in estate planning. If you don't know one, ask an accountant, a financial advisor, or trust officer at a local bank for a recommendation, or consult the directory that the American College of Trust and Estate Counsel maintains of its members, all of whom specialize in this area of the law. This directory may be accessed at the ACTEC website, which is what the American College of Trust and Estate Counsel is often shortened to. So this may be accessed at the ACTEC website at actec.org. That site again is actec.org, all little letters. Number 5, be honest and frank with the attorney about any problems you or your family may have. You may not want to admit that your son or daughter is a spendthrift, alcoholic, or has a mental disability or psychiatric issue, but it is very important that your lawyer know this information so he or she can better assist you in preparing an estate plan that will adequately care for your family after you have died. Number 6, think long and hard before you leave assets outright to your child if he or she is under the age of 25. Instead, consider having the assets otherwise payable to such child passed to a trust for his or her benefit and be held until he or she attains at least age 25. I don't know about you, but my children, before they were age 25, could not handle more than about $50 at a time. And so I had everything in trust for their benefit. In fact, if your estate is substantial, consider having the assets of the trust paid to your child in installments. For example, when he or she attains age 25 or 30, or you could make it 25, 30, and 35, or older if you think it advisable. In some cases, it may even be advisable for you to provide that a part or all of your adult child's inheritance should stay in trust for his or her entire lifetime. For example, if your child is a spendthrift, addicted to drugs or alcohol, or has a bad marriage, you should consider this option, as it will preserve the assets of the trust so your child and his or her children will always have a source of funds to take care of their needs. Now we get to the hard part. Number 7, we have a federal estate tax that may impact your estate plan. Basically, the federal estate tax is imposed with respect to that part of your taxable estate, and that's a term that exceeds the then applicable exemption amount, which is currently $11,700,000. If your taxable estate has a greater value than that amount, that $11,700,000, the excess will be taxed at the flat rate of 40%. If your taxable estate has a value of less than $11.7 million, your estate will currently, and the operative word is currently, not pay any federal estate tax. However, those of you in the audience who currently do not have a taxable estate of $11,700,000 should nonetheless stay tuned, as legislation has been introduced to Congress that would substantially lower the applicable exemption amount, in which event your estate is likely to be subject to that tax. It's very important. To fully understand the impact of this tax, you need to know what assets are includable in your taxable estate for federal estate tax purposes, and the deductions that might be available to reduce the amount of the taxable estate. With several exceptions, most everything that you own at your death whether it is part of your probate estate or not, is includable in your estate for federal estate tax purposes. Thus, all assets owned by you, your life insurance, proceeds payable at your death, and qualified retirement plan benefits like a savings plan or an IRA are all treated as part of your estate for federal estate tax purposes. Please note, for the purposes of determining your estate for federal estate tax purposes, assets held in a living trust at your death are also deemed part of your taxable estate, even though they are not part of your probate estate. Fortunately, in determining the taxable estate, there are two unlimited deductions that are allowed to your estate. These deductions are referred to as the marital deduction and the charitable deduction, and are allowed with respect to any assets passing to your spouse or to charity or to a qualifying trust for the benefit of either. So even if you're a billionaire, if you leave all of your assets to your spouse or a qualifying trust for his or her benefit, your estate will not pay any federal estate tax. This, however, may not be the best estate plan, as your widowed spouse may remarry and bequeath such assets when he or she later dies to the 22-year-old trophy wife or the pool boy, and not to your children. If you're concerned about this possibility, you can provide that upon your death, the assets of your estate should pass to what we refer to as a marital deduction trust for the benefit of your spouse. Your estate will still be entitled to the marital deduction for all of the assets payable to the trust. Your spouse may be the sole trustee of the trust and receive many of the benefits to which he or she would otherwise have been entitled had you left those assets outright to him or her. However, when your spouse dies, the remaining assets will pass to your descendants, I should say to your beneficiaries. That could be very important to you with respect to certain charities that you want named, as you state in your will. You can give the spouse what's called a limited power of appointment, which would enable the spouse to say how it should be paid to your children or to, let's say, certain charities. That's what I have done in my estate plan, because it really means that circumstances change, the tax laws change. It might be very important for your spouse to have that power. Number 8, we also have a federal gift tax that must be considered when planning an estate. To understand how the gift tax works, you must know the definition of the term taxable gift. Basically, a taxable gift is a transfer to someone who is not your spouse that is in excess of your annual gift tax exclusion, again, another term of art, in the amount of $15,000. Under our current law, you can make annual gifts of $15,000 to each of any number of persons in each calendar year without any tax consequences. If you are married and your spouse consents for gift tax purposes to treat half of your gift as if made by him or her, you can also use his or her annual gift tax exclusion. Thus, you can make gifts of as much as $30,000 to each of any number of persons in each calendar year if you're married and your spouse consents to split the gift. So when you are trying to remove assets out of your estate by utilizing the annual gift tax exclusion, the more the merrier. Let's take an example. I have 2 children, and let's assume that each of them gets married, I wish, and has 2 children. I can effectively remove from my estate $90,000 per year, or $180,000 each year if my husband will split the gift. This is a great estate planning tool, especially if you have lots of children and grandchildren. However, you need to be aware of two factors. First, it is best to give cash or assets that have not appreciated greatly since you purchased them, as the recipient of the gift will take your basis and the assets transferred for capital gain tax purposes. Second, while you may love your daughter-in-law or son-in-law a lot, remember that 50% of marriages end up in divorce. And if your child is divorced, your ex-daughter-in-law or son-in-law will be entitled to keep the gifts notwithstanding. Number 9, the federal estate tax and the federal gift tax are interrelated. Taxable gifts made during your lifetime reduce the amount of your applicable estate tax exemption available when you die. To illustrate this rule, assume you make a $100,000 taxable gift prior to your death. The remaining applicable exemption amount that's available to your estate will be reduced to $11.6 million. Thus, at your death, if your taxable estate has a value of $11.7 million, your estate will have to pay federal estate taxes on $100,000, since your applicable exemption amount was reduced by your $100,000 taxable gift. Number 10, just when you thought our tax laws could not get any more complex, I need to tell you that the income tax rules also have an impact on estate planning. For example, it is important that you consider the income tax consequences of how your qualified retirement plan benefits, for example, your IRA, your savings plan, should be distributed at your death. The income tax rules pertaining to these benefits affect the selection of the persons or entities to whom or to which such benefits should be distributed, and the manner by which the recipient should take such benefits. When reviewing how these benefits should be payable, there are two important income tax considerations. First, except for Roth IRAs or Roth savings plan, qualified retirement plan benefits are treated as income to an individual who is the beneficiary once he or she receives such benefits, but is not taxable income to a charitable recipient. Thus, if you are including gifts to a charity as part of your estate plan, any gifts to the charity should be funded with qualified retirement plan benefits, and other assets of yours should be payable to your spouse or your children. Second, as a result of the recently enacted Secure Act, if the value of your IRA or savings plan is quite large, you should review the manner in which such benefits are payable at your death. Under this act, the general rule is that any inherited qualified retirement plan benefits must be taken by the beneficiaries of your plan within 10 years of your death, or a 50% penalty will be imposed. There are a few exceptions to this rule. For example, if the benefits are payable to a spouse, a minor child, a disabled person, or in trust for the benefit of any of them. In closing, there are currently many other estate planning tools available, such as grantor retained annuity trusts, charitable remainder or lead trusts, family limited partnerships, Section 529 plans, and irrevocable insurance trusts that can save a substantial amount of taxes when you later die. Unfortunately, there have been proposals to Congress to limit or eliminate the benefits of some of these options, but nonetheless, those options should be considered. More importantly, other legislation with an even greater impact on most estate plans has recently been proposed. This legislation, if enacted, would reduce the applicable exemption amount that I referred to previously, the $11,700,000. It would limit the benefits of the annual tax exclusion, thus limiting the amount that you could give away during your lifetime using that exclusion. And it would increase the rate of tax that imposed with respect to taxable transfers. So right now, the rate of tax is 40%. To the extent the exemption doesn't cover you, then what happens is the excess is taxed at a flat 40%. If this bill goes into effect, it would be taxable, first of all, at a starting rate of 45%, and it would gradually be a graduated tax. And for those people who give away more than $1 billion, there will be a tax rate of 65%. So one proposal would reduce the applicable exemption amount to $5 million, another to $3.5 million, and even one would lower it to as little as $1 million. While I cannot predict the outcome, I think it is safe to say that it is likely that some parts of this proposed legislation will be passed, and more estates will be impacted by the federal gift and estate taxes. If I am correct, it will be even more important for you to consult an estate planning expert. Thank you very much.
Marsha, thank you. That is amazing information. I was taking notes myself. And I know we have a handful of questions that have come up. For those of you who have already asked questions, please know we will get to as many of them as we can in just a couple of minutes. You are welcome to keep putting your questions in the chat. Evelyn, I see you've raised your hand, and I'm going to ignore you for the moment so that we can get to Pat Van Allen Voigt, but I promise to come back to you if we can, when we can. And now it is my pleasure to introduce Pat. She is currently serving as the Chief Development Director for Faith in the Future, which oversees 15 archdiocesan high schools in the Philadelphia region. Since 2004, she's worked as a consultant for more than 40 school and college clients, as well as nonprofit organizations, to plan and implement capital campaigns, facilitate major gifts fundraising, energize annual fundraising, and advise both staff and trustees on creating philanthropic environments at their institutions. For 25 years, Pat was the Director of Admissions, Development, and Head of External Affairs for the Springside School in Philadelphia, supervising admissions, development, major gifts, planned gifts, alumni, special events, and public relations. Her first job following graduation, though, was Assistant Dean of Admissions for Dickinson. As a volunteer, Pat mentors and advises young professionals. She's presented and helped plan numerous local and national professional conferences on development and admissions for the Council for the Advancement and Support of Education, the National Association of Independent Schools, the National Council for Schools for Girls, and the Secondary School Admissions Test Board. She serves as a faculty member for the University of Pennsylvania Summer Institute for Aspiring Heads of Schools. She didn't include this tidbit in her bio, but I know that Pat has also helped the class of 1966 with its reunion planning efforts. We are so grateful to her for joining us today. And without further ado, I will turn the conversation over to Pat.
Thank you, Christy. I am going to be very brief and very personal because Marsha gave you so much information that is extremely valuable in your estate planning and in your consideration of all of your financial issues. I will speak about why I made a bequest to Dickinson, and it was on the occasion of our 50th reunion. And as Christy told you, I have worked with many schools on planned giving and capital fundraising, and I knew there was a way I could make a significant gift to Dickinson that was not out of my pocket. And since I was one of the chairs of the 50th reunion, I said to my husband, where is our will? He's a lawyer. He was a lawyer. He died last summer. And he told me who to call, a friend of his in Center City, Philadelphia. And I did. And I said, I want to add a clause in my will, in our will, that will go to Dickinson on the occasion of my reunion. And he said, oh, Pat, it's all online. It's so easy to do that. So I went to his office. It took about 5 minutes. His secretary notarized it. They sent off a little copy of that section of the will to Dickinson. And the next thing I knew, I was a member of the Old West Society, which is considerably an honor. Apparently, I didn't know that, but it is. And I get invited to all kinds of events, and it's exciting to be part of this group of people across all ages. Of course, you all know how old we are because of our class years. But these are people of all ages who have made bequests to Dickinson. And I urge you, if you're younger, to think about the easiness of the ease of making a planned gift. If you have an existing will, or if you do not, you certainly should, as Marcia emphasized. I am not a financial advisor. I agree with Marcia completely that you need good, sound financial advice and an attorney. Many of our Dickinson friends have become attorneys, and so you probably have classmates who can help you out. But this is now my 55th reunion, and I was talking to a classmate the other day who's also working on this reunion, even though it's going to be virtual. And he said, well, I have increased my bequest. He also made a bequest at his 50th. And I thought, well, I better do that too. So I am in the process now of increasing a bequest that I made 5 years ago. And it's very exciting to think that you leave some legacy to a place that you love so much. And I do love Dickinson College. There are some women in our class who have been gathering together for, I don't know, 30 or 40 years at least. We actually all roomed together or lived on the same floors in Dreyer and Metzger and Adams. And we get together every single year, at least once a year. We've been Zooming all the time. And those friendships are just precious and irreplaceable to me. I think some of them are on the call, actually. So I urge you to talk to your own classmates, whether it's a reunion or not, about doing something to honor your own experience and what Dickinson meant to you. That's all I'm going to say.
Thank you, Pat. I'm wondering if you can share with everyone, based on your experience, what do you say to people who come to you or to the organizations that you work with, who haven't ever thought about an estate gift before? What do you say to them about why creating a legacy might be important? What is the importance of creating a legacy or talking with a gift officer about what you want to do, whether it's at Dickinson or, like I said, at the organizations that you have worked with before?
Well, I'll tell you another story about one of my schools. And this is not too long ago. I worked for the Agnes Irwin School on a $40 million campaign. The Agnes Irwin School is an old, venerable school for girls on the main line of Philadelphia. And they were going into this really major campaign, but they told me they had a legacy society. And I asked about that and how it had been formed. And they told me the two women had started it on the occasion of their 50th reunion at Agnes Irwin. One of them was the president of Bryn Mawr College, Pat McPherson, and the other one was her kindergarten classmate, Annabelle. They were still dear friends, even well into their 60s and 70s. And they decided they were going to ask every single member of their class to make a planned gift. They were not all bequests. Many of them were bequests, but they were also gifts of paintings, of real estate, they were annuity gifts, which you can create for $10,000, and that you will receive the income from that during your lifetime. So if you want to make a one-time gift and continue to receive income, an annuity gift is a good way to think about it. At any rate, Pat and Annabelle got all of their classmates for that 50th reunion to make a planned gift, and they started the Legacy Society at Agnes Irwin. When I got there to run this campaign, which was about 2010 or 12, there were 250 alumni of Agnes Irwin who had made planned gifts. And during the course of the 4 years of that campaign, and we did reach $40 million, $6 million of that came from alumni who had died during that time. So the impact of this is so important and impressive that you may not realize it at the time you're making a gift out of your estate, but you know, it remains in the endowment in most schools. It is managed by the trustees and the financial people at the college who are very savvy about investing the endowments. And so you know that the money will be well taken care of. And in this case, it made an enormous difference in the campaign. Of course, we had to replace the endowment with that $6 million, but that was a big boost to the campaign. And it was all because of these two women who were so loyal.
That's great. Thank you so much. We have a number of questions. I'm gonna jump in. I know that there's been some good conversation in the chat, so I would encourage you all to take a look there as well. The first question I'm going to ask also touches a little bit on some of the remarks in the chat. It comes from Donna. She submitted it a little bit in advance. I hope she's on the call. But Donna says, I'm interested in hearing strategies for IRAs. What are the requirements for people who inherit them? And are there strategies for minimizing taxes on withdrawals by heirs? When does it make sense to roll over funds into a Roth IRA? Any other ideas on this issue? So that's a long question, and I know that those answers can depend on everyone's own individual circumstances. But I'm wondering, Pat and Marcia, if you can speak a little bit about the value of IRAs as a charitable gift and address some of those concerns from Donna. And if you need me to repeat the question, I certainly will.
Okay, maybe I'll start just with a couple of ideas because I have been wrestling with this issue myself ever since the Secure Act went into effect. But if you have a large IRA, as I mentioned, you really need to have the beneficiary designation for that IRA reviewed, and you should consider several alternatives. One, I didn't want my large IRA payable to my son, and who's a little bit of a spendthrift, because he would have to take it within 10 installments or within 10 years of my death. So he might receive more money than I felt he could really handle. So one of the things I am considering is having those funds be payable to a charitable remainder trust. This trust would be basically would set forth a percentage of the value of the trust each year that my son should receive, and he would receive it over his lifetime. I could have also made it for a term of years. I mean, there's a lot of rules and regulations, but basically the idea is that since the charity is not going to be taxed when they take the IRA benefits, then they will pay out, and I was planning to provide about 5% should be payable. I think that's the minimum that you have to provide, be payable to my son over his lifetime. He will always have, at least he'll always have that sort of like a pension for his benefit. Another thing that you could do is just have a portion of the IRA payable directly to, let's say, an institution near and dear to my heart, Dickinson College. And that way, instead of going ahead and having other assets paid to Dickinson, you could have a part of the IRA or the qualified plan, the savings plan, 401k plan, payable to this, to Dickinson, and have other assets payable to your spouse and your descendants. Another thought that I had was to have, after my death, I'm very concerned. I have a blind cousin, and I want to make sure that I'm helping her out now, and I want to make sure she always has enough money. And so one of the things that I was thinking about doing is having a portion of my IRA benefits payable again to Dickinson to go ahead and set up a gift annuity that would be payable to her over her lifetime. And so those are some of the possibilities. The other idea, you can have it paid in trust, but it would have to be what's called a conduit trust. It won't get around that 10-year requirement, but you could have it depending upon the amount that you're having payable to that trust. If they take it in 10 installments, equal installments, there wouldn't be a great amount of taxes on it each year, is another possibility. But it was a big change. And for all of us, the baby boomers who had salted away money in IRAs and qualified plans, were really, unfortunately, they didn't go ahead and grandfather the amounts that we had in our plan. So we all need to have that reviewed and make some changes. Now, what were the other parts of that question? Her question was like a law school exam, so I'm not sure how we can go ahead and answer all of the parts in 10 minutes or less.
I think we're gonna cut it off right there unless
Okay.
Pat has something she'd like to add, just so we can get to more questions. Pat, is there anything else you'd like to say about IRAs as a vehicle?
It's a great way to give. And for those of you who are over 70 or 70 and a half, I think it is, it's very easy to do that. And you can just turn over what you would normally have to pay to Dickinson. And it's a great way to give. And it costs you not a penny.
Great.
As does a bequest cost you nothing out of your pocket.
All right, I'm going to go to some of the questions that were submitted in the Q&A. Someone asks, what questions should clients bring with them to ask an estate planning attorney? Marcia, do you have any suggestions?
What questions should they have?
Yep.
Well, I think it's better to say what information they should bring. First of all, they need to bring information about all of their assets, their life insurance policies, their qualified plan benefits, whether there's any trust that are held for their benefit or trust that they created. All of this information is really important. And the other, in terms of the questions they should ask, they may want some guidance on the types of persons or entities to name as an executor or a trustee. They may want to talk to the attorney, as I said, about maybe special problems they have, and ask the attorney's opinion on that. So, I normally spent about an hour and a half to 2 hours when I did an estate plan with a client, because it's very important to consider the persons who should be named as trustee. It's a very important role. The trust should be made as flexible as possible because it could last. And one thing I didn't mention during the speech, because I didn't have time, was the fact that for tax reasons, you may want to go ahead and set up what's called a generation skipping trust for the benefit of your child if he or she is wealthy in his or her own right. So, if I were going to inherit money now, I have, I'm not super wealthy, but I do have money that will be includable in my estate. And if I were going to have an inheritance come my way, I would much prefer to have it in a trust for my benefit, so that when I later died, it wouldn't be taxed in my estate. Now, unfortunately, if well, first of all, Congress may change some of this, but even if they don't make any changes, unfortunately, you are limited in how much you can give to a trust and have it pass to in essence, instead of your child, to your grandchild, because there's a limit on the amount, and that's called the GST exemption amount. And today, right now, it's 11,700,000, but that's probably going to change. And some thought was even to make it as low as $1 million. So, that's my answer.
Okay.
And I'm sticking to it.
And one thing we did not talk about was life insurance policies.
Yes.
I think I mentioned that my husband died last summer. He was an attorney, but he worked for the city of Philadelphia for most of his life and for the DA and the EPA. So we were not wealthy, but he religiously put aside money in several life insurance policies, which I was the beneficiary of when he died. And that, again, is a wonderful way to provide for your children, your grandchildren, your spouse. And another thing you can do for the college is to designate a life insurance policy that you no longer need or that your family may not need. So that's just one other vehicle for plan giving.
I'm going to go back to another question that was submitted in advance. And I'm going to start with you on this one, Pat. What should people know about working with multiple advisors? And I'm thinking about you particularly with your experience in development. You, I'm sure, have worked with state attorneys like Marcia, as well as the donor who is trying to connect both the philanthropic interest and the estate interest. What I'd like both of you to answer it, but Pat, if you wouldn't mind first sharing with us what tips you might have for people trying to work with multiple advisors to reach one goal.
Well, first of all, and Marcia is a great example of this, an outstanding estate attorney. To have someone like Marcia in your corner is just beyond valuable, and it will save you a lot of headache if you do it right the first time. And you may, like we did, have an attorney who wrote up your will when your children were little tiny, and you wanted to know what would happen if you both died in a plane crash and who would be their guardians and all of that. And that's usually why people in their 30s and 40s make a will, because they're concerned about the future of their children. But I think that if you're working with a college or a school that your children are going to, and you would like to do something for a campaign or some kind of a charitable gift, the school will also give you good advice. And I know Dickinson, all of you on this call have wonderful resources to share with us as well. Christy's an expert at this and talks with many donors, but I'm sure Christy will tell you that she urges all of Dickinson's donors to talk to their own financial advisors. And that's what I encourage to all of the donors at the schools where I work. It has to be somebody you trust and somebody who knows you and your family.
Marcia, what would you like to add? Anything?
Well, over the years, I have to tell you that financial planners, financial advisors, heads of plan giving at colleges have been invaluable resources for me in helping a client achieve their goals. And I was really glad, Pat, that you mentioned, the resources like, people at schools or your universities or other charities are really a wonderful source for estate planning. But the financial planner is extremely important. It's amazing the information that sometimes they have that I don't, because maybe the client doesn't work with me every year. They may not give me that information. They may only see me once every 5 to 10 years. But the financial planner sees them probably every year, or the accountant, the CPA is invaluable. So definitely they should all work together. That's the best way to handle the process.
Great. I'm going to go to a couple of questions submitted in the Q&A. So let's see. This is a question, and I'm not sure, Marcia, if the answer is different depending on the state, but how can someone add their spouse to the deed on a property to avoid going into any sort of estate in the event of death?
Well, that's a good question. Probably they have to go ahead and hire an attorney who handles the preparation of deeds, and that would normally be a real estate lawyer. I never prepared deeds. I always had the real estate lawyers at Drinker Biddle go ahead and prepare the deeds for my clients. But I have to say that while it's good to include the spouse, you need to also have the advice of probably your estate planning lawyer, depending upon how good your marriage is, depending upon whether or not you have children from a prior marriage. I know of a situation in which basically the children received nothing out of the house, and most of the client's assets were in essence tied up in the house. But she had added her second spouse, and the second spouse did not include those children. He inherited it automatically because she had added him to a deed. So I think you should get advice of counsel before you do so, estate planning counsel, as well as the real estate lawyer.
Great.
Christy, Evelyn has had her hand raised for a while now.
I am trying to find Evelyn, and Evelyn, I don't see your hand up at the moment. Can you try to raise it one more time, and then I'll see if I can click on you. There we go. Let's see. Hold on for one moment. Okay, Evelyn, go ahead. You should be able to talk. You might need to unmute yourself.
Okay. My parents had a revocable trust drawn up 20 years ago. They have no advisor anymore, no lawyer. My mom passed away 4 weeks ago, which makes that irrevocable. And I've been trying to find a lawyer or financial advisor to ask some questions to make sure that we're doing things correctly. And what I'm running into, I'm in the Philadelphia area, is people, I call the office, and what I wanted to do was just pay somebody their hourly fee to consult. But I'm finding, oh, they only do a big package deal. And we don't need a package deal. We need to ask some questions about executing the estate. And my dad, who is 88, wants to update like his trustee on his own trust and maybe update a couple things. Is this some new thing that people only charge by packages, or am I just running into the wrong people?
I think you're running into the wrong people, but also I think that even if you find the right person, you'll need to give probably a lot more information than you otherwise might think you need to give for them to be able to make an informed decision that would be appropriate for your dad's situation and your situation. For instance, when a client would want me to go ahead and make a revision to a trust that had previously been created by another person and not me, or not someone in my firm, I knew I had to review it. And I hate to say this because sometimes that trust or that will was prepared incorrectly. And I can't tell you how many times I found errors that would have been costly for the client. So if I had not reviewed the whole thing, the whole document, and be able to express my opinion on certain parts of it, I would not want to make one minor revision because I could be held accountable for not changing any mistakes that had existed. So that's one thing, Evelyn. You really need to go ahead and probably present the whole situation. Secondly, I don't know the size of your father's assets or what is in the trust, the value of the trust, but there may be, if he lives in Pennsylvania, there is an inheritance tax that has to be addressed. And you may need an attorney for that reason to go ahead and prepare that return for you. Also to go ahead and give guidance. The other thing is, if they're handling the trust, administration of the trust, in essence, they're handling your mother's estate. And therefore, there may be certain requirements, for instance, under the Uniform Trust Act that Pennsylvania enacted, there are certain notices that have to be given to beneficiaries. And depends, maybe your father, because he gets everything outright, it is not a problem. The notice might not be required, but it depends on how that trust is drafted. Let me give you some thoughts on lawyers who might be able to help you. And of course, there are my ex-partners at what used to be referred to as Drinker Biddle, but is now Faegre, Faegre, Drinker. I do not have any ownership. I do not have any benefits anymore from the firm since I retired. So this is not a paid political announcement, so to speak. But one of the persons you could call in the Philadelphia office, with whom I worked fairly closely, was Susan Collins, who is very good at that firm. And if you call the Philadelphia office, you should be able to get them. There's also attorneys in the Princeton, New Jersey office who probably would be able to help you. And if you call my ex-partner, Lisa Presser, she would be able to, she's head of the group, and she would be able to direct you to the right attorneys. Also, one of my ex-associates, Rubina Segal, Segal, is now at Stevens and Lee, and she also would be able to help you. She's very smart and has many years out of law school, where I think she could probably help you a lot. But it's always more complex than I ever wanted for the client. It just is. There, you cannot foresee every situation. So good luck.
I just want to add one thing to that, Evelyn. In the city of Philadelphia, there is something called community legal services. And if cost is a big issue for you, you can do this much less expensively by calling community legal services.
Good idea.
So we still have a couple of questions. We're also at 6 o'clock. I am willing to stick around and go through sort of a lightning round of some of the questions that have already been submitted. Pat and Marcia, if you can stick with us for just a couple more minutes. For those of you who have to leave, thank you for joining us, but we're gonna stick through. We're gonna get a couple more questions answered here, and then we will say goodnight. So next question is, what is the likelihood that Congress will increase the age for the required minimum distribution to 73?
They just raised it. I think they just raised it to 72, if I'm not mistaken. I must admit, since that was after I retired, I don't know the ins and outs. And unfortunately, all of us who were already 73, like myself, since we had to start taking it by April 15th of the year after we turned age 70 and a half. We're all, unfortunately, we can no longer defer. But you could probably just go online and just see. I can't tell you what the likelihood is. I can't even predict the likelihood of, the estate planning, the bills, the estate tax and gift tax. And I didn't even mention one income tax rule that may change, and that is currently at your death, any assets you own receive what's called a step-up basis. So they get a new basis equal to the fair market value of the asset at your death. Unfortunately, what Congress is talking about doing is possibly changing it so that at your death, your family would not get that step-up in basis. And moreover, it would be treated as a recognizable event, which would mean they'd have to pay the capital gains tax as part of when they handle your estate. Not a pretty picture, and I'm hoping Congress will not go ahead and do that. But I'm sorry, I wish I could I wish I had a crystal ball.
I'm going to chime in here quickly with that question and just make one quick comment that while the Congress has increased the age for the requirement to take the distribution, you can still make a qualified charitable deduction with your IRA at age 70 and a half. So for those of you who are 70 and a half or older, even if you're not taking the required distribution, you still can make a qualified charitable deduction from your IRA at age 70 and a half. So there is that to consider. The next question is an elder care attorney the only attorney you need?
I'm sorry, what was that question again?
Is an elder care attorney the only attorney that you need?
The elder care attorney, I am not an elder care attorney, although I worked with primarily elderly clients. I mean, a good portion of my practice was obviously handling elderly clients' matters. I think an elder lawyer tends to focus more on things like Medicaid, Medicare, Social Security benefits. They also do wills they worry about guardians, and they're very important. And especially if you have, a situation in which a parent or a grandparent of yours, or you see yourself becoming, let's say, a little bit where you need that kind of support. I would say you still need, if you have a fair amount of assets, you still need an estate planning lawyer, because that person may be more proficient in the area of tax laws that affect the estate plan and your income tax planning. And so I would say you probably still need both.
Okay.
I would advise you to use the Dickinson Plan Giving Office too, because they are all experts here. And I know they're not going to toot their own horn, but Christy and Beth and other people on their staffs can help you with questions that are complicated, and they have dealt with many planned gifts in various forms.
You are too kind, Pat.
Well, I knew you wouldn't say anything like that. I can say that.
The next question I'm going to answer, I think, it's, do you know of any Dickinsonians still in the profession in the PA, New Jersey, New York area? I know that Pat already, Marcia already provided a little bit of answer there regarding attorneys in the area. What I'll do is send out a wrap up of this conversation, and we'll include a link to the alumni directory so that you can find folks who are involved who are Dickinsonians. So I'll take care of that in the wrap up to whoever asked that question.
I know there's some attorneys on this call.
There are also attorneys on this call. That's absolutely right.
Ross Robinson, an old dear friend of mine, who's a renowned attorney in Philadelphia.
She was a judge, right?
I as well, I think. And I'm sure others. So please, that's a great point, Pat. And so if you are an attorney on this call, feel free to type your name in again in the chat, and that will also be available. Next question is, what are your thoughts on trusteed IRAs? Should they be considered?
Well, it's my
quick thoughts.
I must say, she stumped me a little, because I think most IRAs are considered trustee IRAs. In other words, there has to be either a bank or, even when, there has to be somebody or some entity that holds that IRA. So I'm not sure what the person is really asking.
Okay. Let's move on to the rules for estate tax GST sunsetting in 2025 if they're not changed beforehand. Is that still the case? And how does that affect current estate plans?
Well, it will affect it primarily. What will happen in 2025 is the applicable federal estate and gift tax exemption will be reduced to $5 million, and so would the generation skipping transfer tax exemption. So for any gifts that have already been made, it will not affect those gifts if they're made prior to the sunset. But it will mean that the amount perhaps that you can leave under your will is reduced. Again, a complex area of the law that I strongly recommend a very good estate planning attorney. And by the way, someone who really limits their practice to this area. I mean, in my entire 40 some odd years of practicing law, I only handled estate planning, estate, income tax planning, probate, that was all I did. And it's amazing what you learn by handling a lot of matters. So, life teaches you the most sometimes.
We have a comment and a question about fees. And so fees for financial advising. So I'm not, feel free to answer this if you'd like, Pat and Marcia, and if you feel like this is not something that's in your wheelhouse, that's fine too. But the question is, what is a reasonable range of fees? Let me see. I'm trying to skim through the comment here. What do you? So I'll read the comment. Our former financial advisor charged a fee equaling 1.3% per year of the total value of our assets. It seemed quite high. We weren't doing any active portfolio management, so we switched to an institutional investment company with a virtually identical portfolio. Fees now only 0.3%. What is a reasonable range of fees when you pay fees on that kind of basis? 0.3%, 1.3%. Do you have a sense of what's normal and what's acceptable when you're talking about fees for financial planning?
Is this just for financial planning, or I sort of sense that they might also be asking about attorney's fees for estate planning? And it varies, it really differs. Financial planners tend to charge a percentage of the assets. And there are financial planners and there are financial planners, meaning that some, they can really do different things for you. If it's just investment, then there are also other persons who handle investments who are very knowledgeable that don't charge based upon a percentage of the assets, but maybe charge based upon, when they sell the asset or when they purchase the assets. For instance, stock brokerage firms charge that way. So it really varies for financial planners. I would say generally that it is around 1% if that person is actually doing financial planning for you. If they're looking at your assets, reviewing them, coming up with maybe what portion of your assets should be in bonds, what portion it should be in real estate, what portion, if they're doing the allocations and they're also guiding you with respect to which, brokerage firms you should be using or etc. For instance, our financial planner has done an awful lot with helping us not only, plan our investments, but as to insurance, as to income taxes, etc. He takes 1% and it's money well spent. But yes, you could go to a Vanguard and they'll charge you 3% as opposed to 1%. But you may get what you pay for. So it depends on what do you really want from the financial plan. By the way, lawyers tend to charge based upon a percentage, not a percentage, I'm sorry, based upon their hourly rates and how much time they spend. However, there are some who will quote you $5,000 to do the will. I always was reluctant to do that because some wills I could finish in an hour and a half. Other wills would take me 20 hours, depending upon the complexity of the will. So you have to ask the lawyer what he or she thinks may be the cost.
So I'm going to conclude us with one sort of self-serving question for you, Pat, and you, Marcia. You can please both chime in. But can you tell our guests We still have most people with us. You guys have done it. You are fantastic. Can you tell our guests why you would recommend, if they are considering leaving Dickinson or any institution in their estate plans, why would you recommend them having a conversation with the institution as opposed to, keeping that anonymous? Is there a benefit there for the donor? There's obviously a benefit for the institution, but is there a benefit for the donor? What advice would you give in that situation?
Oh, I always beg donors to not make it anonymous. First of all, you want to thank the donor. It's just good stewardship. And you want to be able to thank them in person, not after they're dead. And I think it sets a good example for other alumni, for other people that you know, to do similar acts of goodwill for their institutions. So making it known that you have made a bequest. I actually just did this last week for my church, a similar kind of seminar for planned giving. We call it the Company of Angels. And we're trying to spread the word among all the parishioners. This is an Episcopal church, to do likewise. That this is a great thing to do. It won't cost you a penny if your children are well taken care of. And of course, we assume that you've made provisions for your family, that this is a very easy way to make a gift. And it's something that we want to acknowledge and praise and thank. In all the schools I've worked with, people's names go on a plaque or they name a building for you. At Dickinson, you will be automatically a member of the Old West Society, which is quite an honor. So I think it's never wise to be anonymous unless you're extraordinarily wealthy, and extraordinarily wealthy people that I know tend not to want other organizations to come to them and ask. So they're somewhat private about their giving. But I think that has changed with people like Warren Buffett and Bill Gates and people who are very public about their generosity. And it sets just a wonderful example for others.
Thank you.
I would also just like to add that, again, if they come to the school and work with the school, they get really a lot of expert advice on how to structure the gift. That can be just vitally important.
Great. Thank you
And
so
you're
much.
not going to charge them $5,000, are you?
No, no, that's right.
But we're also not offering legal advice. We will always say, talk to your attorney, talk to your financial planner. So thank you, Marcia. Thank you, Pat. Thank you to everyone who has stuck with us and asked really wonderful questions. This has been such an invigorating conversation for me, and I hope that you all have learned half as much as I have, because I come away with this with an even better understanding of some of the issues that we're all facing with estate planning than I had before we started. I do want to offer that if there are questions we didn't get to, you all feel free to email any of us. I'm typing my email address in the chat right now. You are welcome to email questions to me, and I will forward them to Marcia or Pat. You can also reach out to Beth and Sam. All of our email addresses are available, and we're all very happy to help with any questions that you might have later down the road as you're thinking through some of these conversations. This program has been part of our virtual alumni week, so thank you all for registering for this and for any of the other events. We are truly grateful for your interest in staying connected to Dickinson. And most importantly, I want to once again thank Pat and Marcia for their excellent advice and warmth and kindness and generosity in sharing all of their expertise with us. My heart is full. Thank you so very much to you both, and thank you to all of you who participated today. Have a wonderful evening.
Thank you for putting up with me.
Yes, thank you.
It was great. Thank you.
Bye-bye.